Welcome back, all right? And for those of you listening on Pulse 89.5, we are indeed thankful that you chose us. All right, and those viewing around the world, hello, welcome. And we just want to thank you for the love right back at you. All right, so we do have our first guest on the line, and that's Martin George, Mr. Martin George, attorney at law. Good morning, sir.
Hi, good morning to you, and good morning to Tobago, and good morning to the wider diaspora that follows the affairs of Trinidad and Tobago, and particularly the business of Tobago.
Very good. I have here as the conversation headline is the THA Act Shortcomings. Let's talk about, and let me just give you, just read this to the public and how the assembly, or what the assembly was about from inception. And it says here, the assembly was created by Act 37 of 1980 for making better provisions for the administration of Tobago and for matters therein. The legislative arm is where all members of the assembly meet in plenary and or in select committees to make policy decisions for the operations of the assembly. That's Act of 1980. Let's talk about what is wrong or the shortcomings of the THA Act.
Well, the first thing I would say is that we had a revision from the 1980 original legislation, and it's now the 1996 legislation that we're operating under, which is found under Chapter 2503 of the laws of Trinidad and Tobago. So it was revised from the 1980 version. So it's now the 1996 version that we're operating under.
Right.
But even this does have some shortcomings because, for instance, even the procedure that is supposed to take place today, where from the notification which was sent by the clerk of the House, which indicates that today's business is supposed to be the election of a chief secretary, when one looks at the legislation, it does not even seem to contemplate such a scenario. Now, of course, the thing is, you ask yourself, given the events which have unfolded, is it that the legislation is to be viewed as that four-legged beast of burden that some people refer it to, in that there's absolutely no way that a chief secretary can be elected if it is not specifically set out in these circumstances? Now, I don't think that that's the way the law is supposed to work. So I would imagine that what has happened is that the powers that be have become a little bit creative in their interpretation or application of Section 8 of the Act. And I will just refer to Section 8 so that we are clear. Section 8 of the current THA Act says, upon the election referred to in Section 7, and that election that they refer to in Section 7 is the election of the presiding officer. And this is the election of the presiding officer after the elections which are held every 4 years. So in other words, after your normal THA elections, which are held every 4 years, then Section 7 of the Act speaks about the election of the presiding officer. Then Section 8 says, upon the election referred to in Section 7, so upon the election of the presiding officer, the Assembly shall elect from among their number the Chief Secretary and Deputy Chief Secretary in accordance with Section 11. So it almost seems to suggest that it is supposed to be a logical sequence. You have your elections, which occurs every 4 years. You then have the election of a presiding officer, and then you have the election of a chief secretary. Now, as we know, in this current cycle or iteration of the THA, that process has occurred already. And this is where the legislation itself is silent, because it never seemed to contemplate a scenario for a voluntary resignation of a chief secretary in such circumstances as have occurred.
Very good.
Therefore, there seems to be no provision whereby they set out to say, well, look, if it is that the chief secretary voluntarily demits office, this is the procedure you apply.
All right. So I just want to, as we deal with the shortcomings, And there is a school of thought that the chief secretaries should not be, or the choice of a chief secretary should not be left to the 12 assemblymen to select among them. I just want to throw that in the mix. Shouldn't there be an amendment to the Constitution or the THA Act to have the general public decide who should be chief and not be left to the whims and fancies of 12 elected assemblymen? Give me your thoughts on that being in the public domain as well.
Okay, but if you take the corollary with the general elections in Trinidad and Tobago, the population does not choose the prime minister, if you understand me. All right, so we need to understand that. And in the same way, under the THA Act, the population doesn't choose the chief secretary. What you vote for at the elections are your representatives. So in other words, under the THA Act, you have 12 representatives for the 12 electoral districts. In the general elections for Trinidad and Tobago, you have 41 representatives, all right, for the 41 voting districts. So it's the same kind of thing operating. So I'm not sure necessarily an argument can be made successfully that the general public should vote for whom they want for chief secretary.
Okay.
Your right is to be able to vote for your representative for your area.
All right, so let's deal with what's happening today. Based on the act, they are following the act to the T. Obviously, we are going to find out.
Well, I'm not quite sure. That's what I'm saying. I'm not quite sure that it's following the act to the T, because the act does not contemplate such a scenario, and it does not specifically set out provisions for this. As I say, rather than let the law end up being something obtuse, I think what they are doing is trying to have a creative application of Section 8. So in other words, you have a purposive interpretation to say, well, look, even though this seems to only relate to immediately after you have your overall elections and immediately after the presiding officer is put in place, it can't be so inane as to prevent you from having to choose and appoint a chief secretary in circumstances where the legislation doesn't specifically set out a procedure.
Because
now,
let
me just finish. That is not to say that somewhere down the road, someone may not test or challenge this procedure, because at the end of the day, there is no specific provision in the THA Act to cover what is supposed to happen today.
All right. Well, and this is where I want to go to. Obviously, this is unprecedented. This has never happened before. And so the Act does not cater or doesn't provide for anyone wanting to demit office prematurely. This has occurred for the first time. Given, and you mentioned that presently the THA members are being a little creative in approaching this from electing outside of the regulations or the rules or the laws, and are doing this as a result of this occurrence that was unexpected, maybe as to accommodate good or getting into or having someone be appointed as chief secretary or selected among the 12.
I would just want to be a little more careful in the use of language. I wouldn't say that they are acting outside of the legislation.
Okay, well,
what
you
I'm
correct
saying is that they are trying to put a purposive interpretation to the legislation.
All right, but is that legal though? Is that legal?
Well, that's what I'm saying. This is something that someone might get creative and mount a legal challenge to it subsequently.
Wow.
So there is the possibility that litigation could flow from this.
So, all right,
at the end of the day,
all right.
just let me finish. At the end of the day, the courts will recognize that in a circumstance where the legislation doesn't appear to spell out everything, you may have no other option but to try to adopt this purposive approach.
All right, so let's go back a little bit, all right? So the chief secretary was elected from the 12, and Kelvin Charles became chief secretary. The president would have either he would have gone to the president house or the president came here and appointed him or did the ceremony, and he's now chief secretary. Now, normally when a government minister is supposed to or is fired or resigned, his position is revoked by the president, or is advised from the prime minister to the president to have this position revoked. That was not done with the present sitting chief secretary. The news came that he resigned. I want to bring the equation. Obviously, the act speaks differently for a chief secretary as opposed to a minister. I want to bring that equation into how do we fix the shortcomings so that in the event it happens down the road, maybe 10 years from now, that we don't find ourselves in this position in relation to what happens nationally.
Right. Okay. So therefore, under the THA Act, they make provision for a scenario where you may have a vote of no confidence. And what it says is that if there's a vote of no confidence in the chief secretary, and subsequent thereto, he does not resign within 2 days of that motion of no confidence being passed, then the president has power to step in and revoke his appointment. Okay. However, if there's a voluntary resignation as occurred here, I'm not sure that there's any need at all for a revocation of the appointment, because in other words, by my act of resignation, I have brought my term of office to an end. I have terminated voluntarily my term of office. So I'm not sure there's even a need for the president to revoke the appointment. I have heard on another program, some persons who are supposed to be in the know saying that there was a process whereby the letter was sent to the president and the president then had to revoke the appointment, and the president had to communicate this revocation to the presiding officer of the House. I don't know about that. I have not seen anything in the media where the president's house has indicated that they have revoked any appointment. And I would be very curious, and I would certainly ask the question as to why the president would have done so if that's the case. So I'm not even sure that there's any certainty as to that having been the process. But I heard, as I say, someone who is supposed to be in the know, touting that on another program, saying that the president had to revoke the appointment and then the president had to communicate to the presiding officer of the House of the THA. So I would love to see the correspondences confirming that, because I would find that very curious in a circumstance where someone has already tendered their resignation, bringing their term of office to an end, as to why the president would think it necessary to issue an instrument of revocation. So I am questioning that, and I would certainly like to see any documentary proof of that, if there's any.
All right. So based on that conversation, they were pointing to what we are trying to get to presently, as to there is also this conversation in the mix that his position as chief secretary, even though he resigned, and I'm going to ask this question now. Is there any legal ground, let's say that the chief secretary can say the Kelvin Charles has resigned, can say, hello, listen, my position was appointed by these 12 people and I am functioning as chief secretary. However, given that I was asked to resign, I was pressured to resign. I did not do this on, or can I claim under duress as to the pressure from my colleagues? From that standpoint, can he stand on any legal ground as a challenge what is going to take place today?
Well, okay, the only precedent of that nature that we have in Trinidad and Tobago would be the Marcia Ayres Caesar type of scenario. If you recall, Marcia Ayres Caesar, who had been appointed as a High Court judge, and then, because remember, she was chief magistrate and she was appointed as High Court judge, And then subsequently, when the entire imbroglio unfolded with all the incomplete matters which she left behind at the magistracy, and the fallout from that, there was an allegation that there was a meeting whereby she was called to the Hall of Justice for a meeting with the Chief Justice, and she signed a resignation letter, that's not in doubt, and that was then communicated to the president. She then met with the president accepted this resignation. Subsequent thereto, Marcia L. Caesar filed a high court action through her attorney, Mr. Ramesh Lawrence Maraj, claiming that, look, this was not a voluntary resignation. I was pressured so to do.
Right.
And therefore, as a result, that is not a valid resignation because it does not constitute my own independent act. Now, the difference in such a scenario is that you had Mr. Kelvin Charles telegraphing to the nation for more than 2 months that he was going to resign, and in the interregnum, he had more than 2 months to think it over, to seek legal counsel, to get assistance, to file any action, to challenge it, if it is that he felt that he was genuinely pressured so to do and had no choice and felt that his rights were being infringed. The Marcia L. Caesar scenario can be distinguished because that is something that happened in the spur of the moment. She was called to the meeting, she was presented with these facts, she then signed this resignation letter, and then this was communicated to President's House. I think all of this happened within the space of a day or two. You're talking about 2 months. So I don't think necessarily there's any legal ground upon which Mr. Charles can look back in hindsight and say, I was pressured for 2 months and I did nothing about it. But now that I realize I have lost the crown, I am now going to seek to initiate legal action. I'm not sure that would necessarily be a sustainable action at all.
All right.
It's very clearly distinguishable from, I think, the only main precedent that we have in such a circumstance, which is that Marcia L. Caesar scenario.
Very good. All right, let's
There's
deal
another
with...
point I thought you were going to be alluding to. This is the question of the position or post of Secretary of Education.
I'm coming to that now.
Because it was put out by, again, persons who are supposed to be in the know. Okay. All right, so do you want me to continue?
Let me just bring it into perspective. The leader of the PNM Tobago Council, Tracy Davidson Celestine, said that automatically, as he resigned as Chief Secretary, his position as Secretary of Education, Energy and Innovation automatically goes out the door as well. I want you to put it, and of course we got Hoche Child responding to that, saying that she's absolutely wrong. The Act does not say that, and he went on to give an explanation. I want you to give me your perspective on that position and, of course, an overview as to whether it is right or wrong.
All right, so actually this is an even more interesting scenario because under Section 33 of the Act provides basically for 9 secretarial positions, all right? And I want to be clear, the Chief Secretary, Deputy Chief Secretary, and a maximum of no more than 7 other secretary positions, okay? So let's understand this. The Chief Secretary, Deputy Chief Secretary, and no more than 7 other secretaries. And these 7 other secretaries are to be notified to the President by the Chief Secretary upon his consultation with the other members. Now, as we know in law, consultation simply means that I have discussed it with you, I have heard your views, but I don't need to take your advice at all. This was first established in the case of Jimmy Bain and the Service Commissions, if you recall, all right? That set the precedent for what consultation in law means. So in other words, I spoke with you on it. Okay, you said A, I ignored you because I want B, and I satisfied the duty. I consulted, right? So the point is, those 7 secretaries would be whom the chief secretary would notify the president. Now, at present in the THA, and for the last 3 years, what we've had is a scenario where you have 7 other positions filled. And then, interestingly enough, you see on the THA website, and it has been a fact of life in Tobago, you see additionally a post called Secretary of Finance, which the Deputy Chief Secretary, Mr. Joel Jack, is supposed to have held. And you see a post saying Secretary of Education, Innovation, and Energy, which Mr. Kelvin Charles, the Chief Secretary, has held. Now, I am saying this categorically, and I'm saying this for persons in Tobago or persons interested in these topics to do some research and check this and see. Those two, if they purport to be separate secretarial positions from the position of Chief Secretary and Deputy Chief Secretary, those 2 positions are illegal. And I want us to be very clear on that. The Act does not provide for you to have 2 postings if those 7 other postings are filled. So in other words, if you have the 7 other postings, which Section 33 allows, and you have those 7, because you have a person like Jomo Pitt and all the others. So you have those 7 filled out. And you also have a chief secretary and you have a deputy chief secretary. Then the chief secretary cannot also, as a separate and independent post, be secretary for education. The deputy chief secretary cannot also be secretary for finance. And I hope, I don't know the inner workings of the THA, and I stay very far from politicians generally, but I hope it has not been the case that these 2 positions have been paid a salary as chief secretary and a salary as secretary for education and a salary as deputy chief secretary and a salary as secretary for finance. Because if that is the case, then there are some very serious questions which need to be answered, because those 2 positions are completely illegal under the Act. And I'm telling you this because the Act says you can have no more than 7 other positions. So in other words, there's nothing to prevent the chief secretary from taking on the responsibility for education. So in other words, you would be chief secretary with responsibility for education.
All right. Okay.
And you can be deputy chief secretary with responsibility for finance. But you cannot be chief secretary and secretary for education. If you look at the THA website now, I challenge you, pull it up now, you will see it's still listing Mr. Kelvin Charles as chief secretary. And so in other words, they have it listed as 2 positions that he's holding. For Deputy Chief Secretary Joel Jack, they are listing it as 2 positions that he's holding. They said Deputy Chief Secretary and Secretary for Finance.
Okay.
Those 2 things are illegal once you have the other 7 positions filled out as secretary.
Mr. George, I want you to stay right there. You've just bitten a juicy bone. And we're going to explore that further when we come back from the break, because I am sure there are people out there with their eyebrows open or their eyes open wide. So when we come back, we continue with Mr. Martin George, attorney at law. He's, and of course, unearthing something there that we may have overlooked. All right, so we go for a break. When we come back, we have lots more for you. Well, welcome back. And our guest, Mr. Martin George, attorney at law. We are here dissecting. In fact, our headline is really the Tobago Act Shortcomings. All right. So you were in the middle of a juicy bone. I want to get in on a piece of this bone and I like to bring now. And we know that no government official, be it in the government sector or in government, cannot be paid 2 salaries. All right. We get that. We understand that. However, let's deal with the THA and the functionings. I'll bring the parallel of the Prime Minister. He's Prime Minister of the country, and in some cases, he has to be Minister of something. I want you to bring even more clarity. In that case, and I bring in the Chief Secretary's position as to bring the parallel or to bring the story in line. Now, so when the Prime Minister is Prime Minister of the country and he is Minister of something else, there is no salary for that, or it's just a position that he occupies, should we say voluntarily? Is it the same thing should apply for the chief secretary in Tobago? And if he's being paid a salary, there are legal ramifications that can follow?
Okay, so let me explain. The difference is that under the THA Act, there is a limit as to the number of additional secretaries that can be appointed. So in other words, the Act provides first for the appointment of a chief secretary, then a deputy chief secretary. That's done by election from among the 12 members. Then under Section 33, it says that the chief secretary shall notify the president of the appointment of no more than 7 other secretaries. So basically, you would have a chief secretary, a deputy chief secretary, and 7 other secretaries as your maximum.
Okay.
So you cannot have, as is on the THA Act, the THA website, sorry, because I just pulled it up and I invite your viewers to pull it up and follow exactly what I'm saying now. Look on the THA website. Look what it's listed there. It says, Assemblyman Kelvin Charles, Chief Secretary and Secretary of Education, Innovation and Energy. Assemblyman Joel Jack, Deputy Chief Secretary and Secretary of Finance and the Economy. So in other words, they seem to be listing each of these persons as having 2 secretarial positions. So in other words, the way they have it worded there, they seem to suggest you are Chief Secretary and you are also Secretary of Tourism, of Education. Then you are Deputy Chief Secretary and you are also Secretary of Finance and the Economy. And where I say it will be illegal is if these persons were receiving a separate salary as Secretary for Education and Secretary for Finance, because the 7 other positions which the law allows are also filled. Because let's look at it. You have Jomo Pitt, Secretary for Sport and Youth Affairs. You have Marcelin Melvin Jack, Secretary for Community Development. That's 2, right? You have Shomari Hector, all right? Secretary for, not Shomari Hector. You have Hayden Spencer, Secretary for Food. So that's 3. You have Clarence Jacob, Secretary for Settlements. That's 4. You have also the Councillor Kwesi Devine, Secretary for Infrastructure, Councillor Nadine Stewart, Secretary for Tourism, and you have Councillor Tracy Davidson, Secretary for Health. So those are your 7 other secretarial positions which the law allows. So therefore, you cannot then create a position legally of Secretary for Education and be paying someone a salary as Secretary for Education. You cannot also create a position legally of Secretary for Finance and be paying someone as Secretary for Finance and have them carrying this title separate and apart from their title of Deputy Chief Secretary. And same way with education, you cannot have someone carrying the title of Secretary of Education separate and apart from their title of Chief Secretary.
Okay.
So it is not permissible once you have the 7 other secretarial positions filled out. So I would like people in Tobago to make inquiries and find out, were these people paid 2 salaries? Because if you have been paid a salary as Chief Secretary and a salary separately as Secretary of Education, then there ought to be a major inquiry as to why this occurred, because this clearly would run afoul of the legislation once the 7 other secretarial positions have been filled out. Now, I want to be clear, right? This is a little bit complex, so we need to take some time to go through it. Let me make it clear. It does not mean that as Chief Secretary, you cannot assign to yourself a portfolio of work. But all it is additional work. It's not additional pay.
Very good.
We need
But
to understand
good.
that. So in other words,
all right.
I can say, just let me finish this because I want people to be very clear.
Yes.
I can say I am Chief Secretary and I am taking on the additional portfolio of being responsible for education, innovation, and energy. So in other words, then my official title will be Chief Secretary with responsibility for education, innovation, and energy. So in other words, it is clear that I'm only holding one position of Chief Secretary, but I have responsibility for the areas of education, innovation, and energy. Same way with Deputy Chief Secretary, I can say I'm Deputy Chief Secretary with responsibility for finance and the economy, and that would be perfectly fine. But once the 7 other secretarial positions have been filled out, I cannot hold the position officially of Chief Secretary and also officially hold the position of Secretary for Education. I cannot, once the other 7 positions have been filled out, hold the position of Deputy Chief Secretary and also hold the position of Secretary of Finance and the Economy. And I think for the last 3 years, correct me if I'm wrong, it appears to some people that Mr. Kelvin Charles has been Chief Secretary and has also been Secretary of Education. It appears for the last 3 years or more that Mr. Joel Jack has been Deputy Chief Secretary and has also been Secretary of Finance and the Economy. And the question would be, were they being paid 2 sets of salaries for those positions? If that's the case, then I think, and I mean, of course, this is not an attempt to point fingers or cast blame. It's just really for us to try to understand the act and to ensure that going forward, such errors are not made. So I think, and I mean, it's my respectful and humble suggestion, that in future, once you have the 7 other secretarial positions filled out and you want your Chief Secretary to have a portfolio, the more correct way legally to word that would be to say Chief Secretary with responsibility for education, innovation, and energy, Deputy Chief Secretary with responsibility for finance and the economy.
All right, Mr. George, there are those who are listening and may ask this question. It has been the practice when Ove London was in office and before him, there were secretaries who were deputy, Cynthia Alfred was deputy chief secretary, and she was secretary for culture and other positions. And that question that you're raising now, or that concern that you're raising now, has never been brought to bear on the minds or the psyche of the people as to thinking whether or not they have been paid for this. Let's say an investigation is launched now, and they are found out to be guilty of receiving 2 salaries. What can happen?
Well, I wouldn't want to use the term guilty. I always try to be very circumspect and cautious in my language. The point is, if for whatever reason they were paid 2 sets of salaries, then I think some questions would arise as to how you are justifying that under the legislation, given that there are the 7 other positions filled out. Now, and let me just to complete the loop, right, because this is a very interesting and intricate area of the law. To complete the loop, it does not mean that as Chief Secretary, you cannot also be appointed as a secretary separately. And similarly, as Deputy Chief Secretary, doesn't mean that you cannot also be appointed as a secretary separately. However, what you would have to do is make sure that those 2 appointments form part of the 7 that the legislation allows under the Section 33 of the THA Act. So in other words, 2 of the others will have to be bumped off the list to make way for you to be officially appointed as Chief Secretary and for you to also be appointed as Secretary for Education. Well, you don't list the portfolios. All you do is notify the president of who the 7 secretaries are. So therefore, if you want, so you can, in those circumstances, carry out those 2 separate and distinct functions and carry those 2 portfolios, but you must be among the 7 names that are sent to the president, and therefore you will now have a separate swearing in. And this is the important part. You will have a separate swearing in as secretary, and therefore you will then now officially take on the portfolio of Secretary for Education, You will have a separate swearing in as secretary. So this is separate and apart from your deputy chief secretary swearing in. And in that separate swearing in as secretary, you will then now take on the portfolio of finance. If that is not done, then when you have all the 7 other secretarial posts notified to the president, and your name is not there, the deputy chief secretary's name is not there, but subsequently you are calling yourself, or you are being named and being listed on the THA website, and as I say, you can check it now, live and direct as we speak, you will see it listed there still. Kelvin Charles, Chief Secretary and Secretary for Education, Innovation and Energy, Joel Jack, Deputy Chief Secretary and Secretary for Finance. So in other words, it appears on the THA's official website that there are 9 secretaries separate and apart from your official post of Deputy Chief Secretary and Chief Secretary. The legislation limits you to no more than 7. Section 33(1)(c) of the THA Act says such other secretaries not being more than 7. So therefore you ask yourself, when you look at the THA website, how could they be listing 9 secretarial positions? That is what I'm saying is illegal. You cannot list it that way. You cannot basically have 7 secretary positions, and then you are saying additionally, Secretary for Education, and also the person is Chief Secretary separately, Secretary for Finance, and also the person is Deputy Chief Secretary separately, because then 7 plus 2 makes 9 secretarial positions, plus Chief Secretary, plus Deputy Chief Secretary. That is illegal as far as the legislation is concerned. And that's the point I want to bring to the attention of the Begonians. Now, as you say, it may have been occurring for years in the past, but not because something has been done wrong all the time means that it was right. For centuries, people thought the earth was flat until we discovered otherwise.
Okay,
For
so
centuries, we thought the earth was the end of the universe until we discovered otherwise.
All right, so we discovered otherwise today, Mr. George, and this is revolution. We have discovered that today. How do we, going forward now, how do we fix that? How do we ensure that our elected officials in the THA follows the act to the T, according to what you are saying? As I said, it happened in the past, nobody challenged it. Yeah, how do we fix it going forward?
Right. You have 2 choices. One, if you want to take on the additional portfolio, you can take it on by simply saying Chief Secretary with responsibility for education. So in other words, it is clear that you only have 1 appointment as Chief Secretary. However, you have responsibility for education. So in other words, as I say, it's additional work, but no additional pay.
Right.
We need to understand that.
Yes.
You can also be Deputy Chief Secretary with responsibility for finance. Again, additional work, but no additional pay. If you want to also be in a scenario where you are saying that, look, I want the official title of Secretary for the portfolio of finance, then you must knock off 2 of the 7 that you have. And now you and the Chief Secretary must also put your names forth to the President. So therefore, when you see under Section 33(2), it says the Chief Secretary shall consult with members before he advises the President in accordance with subsection 1C. And you look at subsection 1C, it says, right, such other secretaries not being more than 7, selected from among the members of the Assembly as the President acting in accordance with the advice of the Chief Secretary may appoint. So therefore, if you want to have it as an official title, you must notify the President at this time and say, listen, I am also putting forth my name to be a secretary. Even though I already have the post of Chief Secretary, and I'm also putting forward Mr. Joel Jack's name to also be a secretary, even though he's already in the post of Deputy Chief Secretary. And therefore, you will then only have 5 other secretary positions that you can notify the President for. So in other words, 5 plus 2, that makes 7. You cannot do, as appears to be the case here, have 7 others filled out and then want to be carrying the title officially as Secretary for Education in addition to the post of Chief Secretary or Secretary for Finance in addition to the post of Secretary a deputy chief secretary.
All right.
So it could just be a description, if you wish. And as I say, the better way to describe it would be deputy chief secretary with responsibility for finance.
What if,
so in other words, there's no obfuscation. It could not appear that you're trying to hold two portfolios.
Yeah.
And same way for chief secretary with responsibility for education.
All right. What if that was the intention and the labeling or the title was blown out or put in the wrong perspective, as you are recognizing it now?
So
what if it was...
I'm actually giving the THA the benefit of
the doubt,
that it may just be a case of unhappy wording, or the way they express themselves has not been clear. So that's why I'm saying the only way you will know for sure if the intent was different is if these persons were being paid two salaries and if they were officially carrying two titles. In other words, if I am officially addressing you as Secretary for Education, separate and apart from your portfolio as Chief Secretary, and you are carrying out those functions and receiving a salary for it, then that raises question.
Very good.
If I'm officially addressing you as Secretary for Finance and you are receiving a salary separate and apart from your salary as Deputy Chief Secretary, then that raises question.
Very good.
So, as I say, it may just be unhappy wording or inelegant use of language by the THA. And I think the more elegant way they can describe it in future going forward would be Deputy Chief Secretary with responsibility for finance.
All right.
So Chief Secretary with responsibility.
Yeah, and I think, and you're absolutely right. Let's hope that that is sorted out. But anyway, today they are going to elect a new Chief Secretary. What do you suggest, or what do you, in fixing all that you've spoken to, as we try to ensure that we cut the shortcomings out of the THA Act? Today, a new secretary will be chosen, Chief Secretary. What do you suggest that we do going forward with this new person at the helm of the THA?
Well, the thing is, it's actually not connected in any way whatsoever with who you appoint or don't appoint. I think generally for the good of Tobago, we need to recognize that there are some shortcomings in the present legislation, and this THA Act definitely needs to have a second look. And of course, that's the way law works. Law is a living, breathing thing. So as time goes by, you recognize, okay, this is not working as good as we should, as it should. We need to fix it. We need to tweak it. We need to amend it. And I think we just need to recognize that we've reached that point with this THA Act. So therefore, we have to now have a look at it whereby we say, look, we need to amend it, we need to fix it, or we need to revise it totally. But the thing is, there are definitely some shortcomings because you don't even have a provision which caters for the voluntary resignation of a chief secretary or a deputy chief secretary. So therefore, that's why we're in uncharted waters today. And that's why I hope that, they dot all the I's and cross all the T's, and that we don't end up in a slew of litigation arising out of this process today, because there is no specific provision set out to deal with it. But of course, you can't legislate for everything, and the courts recognize that. So that's why I say sometimes you have to adopt a purposive approach and interpretation to legislation, which allows you to cure lacunas in the law, such as what we have at present. So even if it's challenged, it may very well be that the court may say, look, we understand that it's not specifically set out in the legislation. However, in this circumstance, we appreciate that there would have been no other choice than to apply a purposive approach to the interpretation of Section 8.
Very good. Mr. Martin George, I think we have you, they should be, you should be employed as the THA's attorney to guide us and to guide you to...
No, not at all, thanks.
But anyway, I am really filled. And,
I'll tell you, Brother B, I love the fact that you and I always engage in these intellectual discourses because it's a way of enlightening and sharing information, educating people, illuminating subjects and topics. It doesn't necessarily mean that you and I are right or wrong or whatever, but by raising these issues and stimulating and generating discussion on a higher plane, we are able to elevate our minds and lift our consciousness as we all strive for a better today.
All right. Thank you, sir. And stay safe. It was really, really informative, and we really are better off in terms of having the knowledge about the THA Act. And a number of people are going to go do the research from today. So we want to thank you for that.
So. I certainly think so, because questions are going to be asked.
Very
Thank
good.
you. Have
All
a
right.
good morning.
Thank you, my brother. Have a wonderful day and be safe. Yeah. All right. So that's Martin George, and clearly, now you know, and we know legally you cannot be working in any government agency and be paid two salaries. That's illegal. If that happens, then clearly you are doing something illegal. However, as was raised by Martin George, if an investigation is launched now into the THA and there's evidence of that, then clearly, then we know how far that can go. So I would hope that, according to what he was saying, that the titling is wrong, and that they make the necessary amendment to the THA Act to accommodate the positioning of individuals and carry the right title. So it was really, really enlightening and informative. At this point in time, we go for morning news. When we come back, we speak with another gentleman that I really like speaking with, and that's Mr. Shane Mohammed, political scientist. And we'll have a conversation about the political landscape. Remember, after COVID is election. So see you after this morning news.